My name is Melissa Roy, and I'm the college's Chief Diversity Officer. On behalf of the Office of Diversity, Equity, and Inclusion and the Departments of Criminal Justice and Legal Studies, welcome to What Have We Learned from the Derek Chauvin Murder Trial. Less than a year ago, America watched the life drain out of George Floyd as he lay prone on a Minneapolis street. Floyd, an unarmed Black man who was handcuffed, pleaded that he could not breathe as Derek Chauvin, a white police officer, knelt on his neck for almost 10 minutes. Chauvin knelt on Floyd's neck even though Floyd was not resisting, and continued even though he was unresponsive. Initially, Floyd's death was reported by the police as a medical incident while in custody, but a video recording told a different story. Floyd's death ignited nationwide protests and focused a spotlight on questions about social justice and criminal justice. Last Tuesday, a jury in Minneapolis found Chauvin guilty of murdering Floyd. That verdict accomplished two things, in my opinion. The verdict affirmed that Floyd's life mattered and that Chauvin must be held accountable for his actions. Did the verdict accomplish anything else, though? We've assembled a panel of experts to dive into that question. They'll begin by answering a few questions about the basics so that we all understand the nuts and bolts. They'll next answer questions that cover factors that may have affected the verdict, and they'll finish by answering questions about social justice. Before we continue, I will remind you to please remain muted until asked to speak. Feel free to ask questions using the chat function at any time, but there will also be an opportunity to ask questions later in the program. We are recording today's program and we'll post it on the Diversity, Equity, and Inclusion website. Now let me introduce tonight's panelists. Dr. Michael A. Baston is Rockland Community College's president and as an adjunct instructor in legal studies and paralegal studies. Dr. Baston began his professional career as a public interest lawyer representing educational corporations, religious institutions, and nonprofit organizations. He credits powerful experiential learning opportunities while in law school as the catalyst for pursuing that path, including serving as a student law clerk for the NAACP Legal Defense and Educational Fund, and the Honorable Judge Ronald L. Ellis, U.S. Magistrate Judge for the Southern District of New York, Brooklyn Legal Services, Corporation A, and the Brooklyn Mediation Center. Dr. Kishon Hickman has been an adjunct instructor of criminal justice for the past 11 years. He is a 19-year veteran of the New York City Police Department, holding the rank of lieutenant and assigned to the Information Technology Bureau. David Panitz, Esquire, is a trial attorney with 29 years of experience focused on civil and municipal litigation. He is an adjunct instructor at RCC, who is currently teaching contract law and litigation, serves on the advisory board for the Legal Studies Department, and is mentoring students for this week's mock trial program. Patricia E. Szobonya, Esquire, is associate professor and program director for criminal justice and legal studies. She is licensed to practice in New York and New Jersey and maintains her practice as a general solo practitioner. LaTanya M. Watkins, Esquire, is an attorney in private practice in New City, New York. She is a formal legal redress chairperson for the National Association for the Advancement of Colored People, also known as the NAACP, as well as the recent co-chair of the Rockland County Sheriff Police Reform Panel. Panelists, thank you for joining us today to examine what we've learned from the Chauvin Murder Trial about social justice and criminal justice in America. Let's get started with the basics. So we'll start with you, Professor Szobonya. Please explain the charges against former police officer Derek Chauvin and why the prosecution chose to file those charges.
Sure. The prosecution filed 3 charges against Derek Chauvin. The first one, I'll start with the heaviest one, would be the second-degree unintentional murder, also known as felony murder. So what the prosecution had to do was prove that Derek Chauvin was responsible for the death of George Floyd when he attempted or committed a felony. Now, the felony in this particular case would be third-degree assault. So again, taking it further under Minnesota law, third-degree assault would be defined as intentional infliction of substantial bodily injury. So just to point out that the prosecution did not have to prove that Derek Chauvin intended to murder George Floyd, but had to prove the intent of committing the assault in the third degree. So the second charge then was murder in the third degree. And this particular charge was that the prosecution had to prove that Derek Chauvin committed an act that was eminently dangerous toward others, evincing a depraved mind and having a reckless disregard or a disregard for human life. Now, this was the charge that initially was thrown out. The defense counsel for Derek Chauvin had filed a motion, and interestingly enough, it's because of the way that the criminal statute reads, it says eminent act dangerous towards others. So the defense argued that George Floyd was a single person, this was not others. Judge Cahill did decide on the motion and did throw out the charge, did go up on appeal. And it was determined that Judge Cahill was wrong. And in fact, that was restated as we know. So that charge was back, and we know the outcome. The third charge then was second degree manslaughter. And this would be the easier or the lesser standard, the easier charge to prove. And the prosecution here had to prove that Derek Chauvin was culpably negligent, that he created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Guess you can ask why the prosecution did not decide to have the charge of murder in the first degree, and that would be because you would have to prove that that Derek Chauvin intended to murder George Floyd, which would be much more difficult.
Thank you.
You're welcome.
So that takes us right to the question for Professor Panitz. Please explain burden of proof. Who has it in a criminal trial, what the standard is, what it means, how does it differ from the burden of proof in a civil trial? You're on mute.
Thank you for that. I appreciate it. So the distinction really starts with obviously the burden of proof being significantly higher in the criminal setting. So what we're looking for in the criminal court is a prosecutor proving beyond a reasonable doubt that the charges have been shown. So what does that mean, beyond a reasonable doubt? The prosecution has to convince the jury on at least one of the three charges that Professor Szobonya talked about, that there's no other reasonable explanation that can come from the evidence. In other words, the jury has to be virtually certain of a defendant's guilt in order to render a guilty verdict. Now, in the civil court, we hold up the scales, right? We have to tip the scales just ever so slightly in favor of the plaintiff, which is something greater than 50%. And we also have potentially in the civil case, two big issues that have to be proven. For example, in a negligent civil case, you have to prove liability and you have to prove damages. So we don't have the same kind of exposure of civil liberties in the civil court. That's probably the main reason why we make the burden so high in the criminal court, because of loss of someone's ultimate right and freedom, right? The downside of losing is prison in many cases. Now, obviously, there are lesser sentences. Someone could get probation, someone could get a fine. But in Minnesota, we were clearly looking at the loss of liberty, right? So there's a huge difference between the civil and the criminal. The civil is called a preponderance of the evidence. Preponderance. It's a word that doesn't get in a lot of conversations, but it's certainly something that tips just in favor of proving more likely than not, okay? In the criminal setting, we add certain safeguards, okay, to protect criminal defendants. Number one, a presumption of innocence. So there was a presumption in favor of this police officer in Minnesota. Despite what people believed and heard going into the trial, you start with the presumption of innocence. We also have a certain amount of constitutional rights that really rise up. The right to an attorney. You don't have that necessarily in a civil case. A private, if you can't afford an attorney, they'll provide you with one. You don't have that in the civil case. The right not to be forced to incriminate against yourself, the Fifth Amendment. You don't have that necessarily. You can be subpoenaed. You can be required to testify in a civil case. A judge can compel that, not in a criminal standing. Because again, we're looking at a very serious outcome in many. You also have the right to confront and cross-examine people who are testifying against you. So I come back to the big picture is that we look to see the severity of what the harm is potentially to the suspect, if you will, and we put certain protections in place. We make the prosecution work hard. In Minnesota, the jury said within 10 hours that the prosecution had met their burden. So that's the system. And there may be a right of an appeal. I assume there is a right of appeal. I assume they'll appeal that. But, thank you for asking. That's, I hope, a good explanation.
It was. Thank you very much. So I'll turn to you, Dr. Hickman. In this case, we were talking about how reasonable was the former police officer's action. So would you please explain the use of force continuum?
Sure. Thank you. Thank you, Melissa. The use of force continuum is essentially formulated by two Supreme Court cases. And I'm going to give you the fact patterns for those two cases and then kind of elaborate. The first case that we talk about when we talk about use of force is Tennessee versus Gardner, where officers were dispatched to a burglary and they were met by 15-year-old Everett Gardner, who was fleeing from the rear yard of a house. And as he was fleeing from this rear yard, he had nothing in his hands, and the officers actually fired a round at him because he was essentially considered a fleeing felon. Now, up until this case, this was kind of where we pivoted with use of force. Up until this case, we could legitimately, as police officers, shoot at a fleeing felon, which has since been overturned. And this was a game changer for policing. The second case that we talk about when we talk about use of force is Graham versus Connor. And this is a 1989 case where the setting is North Carolina. It's I think it's November 12th of 1984. And this guy, Graham, is in a car with his friend. Graham's diabetic. He's got some serious diabetes. And he's having some sort of attack where he says to his friend's name is William Barry. He says to his friend, rush me to get me orange juice now. I need orange juice now. I gotta do something with my sugar. And so they send him to this, so they look, the first gas station they see, they pull in. And Connor walks in, or Graham walks in, there's a long line. He says, I can't wait for this line. So he comes back out. And a police officer, right? A police officer named M. Connor said, wow, this looks kind of suspicious. I'm a little bit raised to this. Why does the guy go in, come out with nothing, right? But he didn't know the backstory. So he pulls him over. He says, let me investigate this a little bit, right? And then he activates his turret lights, right? Lights up this car. We pull him over just like I've done thousands of times out there in the streets of New York City. The guy gets out of the car, and amazingly, he gets out of the car and he collapses right in front of him. So now he thinks, all right, well, this guy's drunk. Like, what all these conclusions come to your head? And so he goes up to this guy who's seemingly drunk or appears to be drunk. And what does he do? He handcuffs this guy. So this made what's called the Graham standards And you know, obviously this officer was wrong. He was sued, and then we made what we call the Graham standards, right? And those are three things that we really drill down on when we say, well, when do we use force as police officers? Number one, what is the severity of the crime that we suspect, right? Right? Is this a bank robbery or is this a noise complaint? Right? And we've got to figure out which. But our use of force should only be in our mens rea, in our culpable mental state, to that battery, right? So the second thing is the suspect an immediate threat? Right? This guy that's collapsed on the ground, is he immediate threat? No, right? And was the suspect or is the suspect resisting arrest? So when we look at these three items and we talk about how they relate to the current trial that we're discussing today, right? What is the severity of the crime, right? Floyd was suspected of passing a fake US currency, right? $20 bill, right? Is that an immediate threat? Probably not. And was he resisting? I mean, we saw excerpts of the tape. So this made, right, these Graham results made what we call the force continuum. And the force continuum is basically five things: physical presence, verbal commands, open hand conduct, lethal or less than lethal weapons, right? And up to and including deadly force. But as a final note, I want to ensure that everybody understands that when we talk about this use of force continuum, what dictates how the police use force is how forceful the suspect is, right? Who's going to be on the receiving end of our force and what level are they at? Because we're going to either match or go one above, right? As all five officers in the Minnesota Police Department testified to, right? Where are we at, right? What's Floyd using? What does the officer use? It's either in line with each other or the officer is one above. And that's what comes down. And that's a very simplified version of the two cases that derive our use of force standards in America.
So that's very helpful because that takes us right to Dr. Baston, who I'm going to ask to tell me what the key arguments were in the prosecution's case.
Well, I would say it in this way. The art of any argument really will line up with many outcomes. In this case, the art of the argument is the visual evidence. And so the video testimony becomes the star witness in this scenario. Our ability to follow all of the others who are giving input into the conversation, those who work in the police force and who are saying that, in fact, the ways in which this matter was handled were inappropriate, is one thing. But what the prosecution did very skillfully was to say, believe your eyes, believe what you see. The fact is, the defendant had the right to testify and the right not to testify under the Fifth Amendment. And ultimately, the prosecution then allowed the visual evidence of the actual killing of this man become the testimony that had to be addressed. There were several other instances of different video footage from the other officers on body camera, as well as the video evidence produced by those who are watching this specific set of circumstances play out. And it is in that way that that video camera becomes a critical eyewitness to the tragedy that took place. And therefore, I believe the prosecution had the ability and the art of the argument to say, believe what your eyes see.
Absolutely. That evidence was truly compelling. It was also painful to watch. So then I turn to you, Ms. Watkins, and say, what was the most effective portion of the defense's case?
I feel like I just lost to Dr. Baston. Thank you. So, as I believe Professor Panitz alluded to, it's never the responsibility of the defense to prove that someone didn't do something. the prosecution has to prove each and every element of the crime charged. And that's each and every element. And the ability to not allow them to do that by effective defense causes the reasonable doubt that's necessary for an acquittal. So obviously, with the unanimous verdict on all three charges, the defense was not effective in doing that. They were not effective in demonstrating that Derek Chauvin was not criminally responsible for the death of George Floyd. One potentially effective, it's difficult to say what's effective when they lost, but one effective defense strategy was the resisting arrest defense, that the use of force was necessary against George Floyd because he was resisting arrest. We saw in some of the video coverage that George Floyd, appeared to not want to get in the vehicle. And it doesn't even matter at this point why he didn't want to get into the vehicle. He was over 6 feet. He was a large man. It was a small space. There are lots of reasons why. But that, in the very simple definition of resisting arrest, is resisting arrest. So the defense counsel argued that a reasonable officer would conclude that the amount of force used by the two officers to get him in the vehicle was insufficient to overpower Floyd's resistance. So that justified an escalation that I believe Dr. Hickman mentioned. If the resistance is here or the amount of force is here, then they can go equal or above. So resisting arrest under New York law is a person is guilty of resisting arrest when he intentionally prevents or attempts to prevent a police officer or peace officer from effecting an authorized arrest of himself or another person. That seems very clear and actually quite simple, except that there's an issue of a lawful arrest. What is a lawful arrest? I don't want to go into the detail of that, but it would appear just on its face that what George Floyd's actions resisted the arrest. So the problem with that theory is the almost 10 minutes of the knee on his neck, which resulted in his death, what that did was when his resistance ended, the use of force should have ended as well, and it didn't. So although there were several other defenses regarding his drug use and whether the drugs killed him, whether the drugs caused him to have a heart attack, whether his pre-existing heart condition caused him to die, whether the participation verbally of the surrounding people who are observing this horror, whether they contributed by causing the officers to believe that they needed to be focused and not distracted by the people and safe from the people. All of those defenses could have resulted in any of the jurors finding that there was reasonable doubt, but I'm grateful and thankful that it didn't. So thank you.
Thank you. So it's time for our first poll and an opportunity for our audience to participate. The trial and its verdict attracted more attention than any criminal proceeding in decades, truly. And the trial itself was recorded, broadcast, and live streamed in audio and video. What we want to know is, did you watch or read any of the media coverage? So you can click the box appropriate to your response, and we'll give you about 45 seconds more to answer, and then I will go ahead and share the results with you. Great, thank you. So most people said that they watched or read some of the media coverage, 40%, not quite a majority at this point, but quite a few of the people who participated indicated that they, excuse me, watched or read some portion of the media coverage. Thank you for participating. So now that we've level set, so in other words, we've made sure that everybody understands the basics of what took place during the trial, I think it's time to proceed to a discussion of factors that may have affected the verdict. So again, I'll start with you, Professor Szobonya. Do you think the historic $27 million settlement between the family of George Floyd and the city of Minneapolis affected the jury's verdict? And then a follow-up question would be, do you think the timing of the award of the settlement impacted Chauvin's ability to get a fair trial?
Personally, no. although I can understand because it's an exorbitant amount of money. However, I trust that Judge Cahill, when the settlement came out, and of course the defense counsel said that Chauvin would not be able to receive a fair trial since the news broke. Judge Cahill did go back to the 7 jurors that were already decided upon. And I think that was really important because what came out of that was that 2 of those jurors did say that they would be impartial based on the fact that they heard it was $27 million and that they would assume that meant that there was wrongdoing, and they were removed. So the rest of them were there. In fact, that day they had just put on 2 more jurors. So there was a total of 9. They dropped 2 and they were back at 9. And at the onset, the jury had already made a promise that they would only consider the evidence that was introduced at trial. And furthermore, the judge had told them to avoid any news media coverage. Not that that's possible for everybody, but again, that Judge Cahill went back to the jurors to be honest and say it's going to impact me. The rest said no. And I think at the onset, when they were selected to begin with, that this jury pool, they wanted to be there. It's not really common that you're excited to be on the jury, right? And especially with this case, you'd have to really look at it. These people wanted to be there to render a verdict, to listen to really what happened. And I think that they took it seriously. As far as the timing, I again would have to say, no, I think that Derek Chauvin did receive a fair trial. Could it have been held off? Well, according to the city, no, that they had no control and that they were their own entity to come out with that. I don't think that it had an impact.
Thank you. So Professor Panitz, the prosecution took a pro-police stance in their closing argument. Do you think that had an impact on the jury's verdict? And how police might view the verdict?
Yeah, I think the answer is yes. Definitively on your first question, that it had an impact, but I don't think that would be fair to conclude without looking at the totality of how that was accomplished. I don't think that came first. I think what came first was a witness's video here that I think it was a teenager who recorded this bravely. And it's quite distressing to many of us at how there's this standard out there among the police civil trials and criminal trials as what is known as the blue wall of silence. And I don't have to tell most of you about it because we heard before the trial and during the trial a lot of references to the kind of testimony that was going to come out. And then we saw here 4 significant witnesses testify. We saw the chief of police admonish Mr. Chauvin. We saw the longest serving police officer admonish Mr. Chauvin. We saw Inspector Blackwell explain that also, reasons why it was inappropriate, it was serious misconduct. And then I believe his own supervisor testified and admonished him. So I do think this had a huge impact on the jury. But I also will say in civil trials and in criminal trials, I have seen, particularly in the civil side, jurors come in wanting, as Professor Szobonya said, they want to get it right. We do hear about these aberration rulings. I won't mention them, but we know they're out there. But I think that most of the jurors in our society, they try to get it right and they get it right. So yeah, I do think it had an impact, but I think it was a fair impact because there was testimony. Does that help? I think there was a lot of evidence here. The second question I think you asked, I I actually would defer to the lieutenant on this because I'm not sure how other police would view it. My sense would be relief. I would suspect that a lot of officers in our country privately expected the verdict and wanted that verdict. I don't know whether they'll come out and say that, but you've seen in the post-verdict analysis on several channels, the police coming out, I think, uniformly behind the verdict. But I would defer to the lieutenant for a better answer. Thank you.
Thank you. So it's perfect time then to chat with Dr. Hickman. Why do you think members of law enforcement were willing to testify against Derek Chauvin in the trial? In circumstances that in other trials, they have been unwilling to participate when there's a question of police misconduct. What was different here? You're on mute.
So it's interesting you asked this. I actually had this, Dr. Baston is smiling because he and I had this conversation privately before, long before this incident, and just about the juxtaposition that I am in as an African-American male in the law enforcement profession, and then encouraging others and other students here to aspire to be in the law enforcement profession as well. This case drew really what I consider worldwide attention to what Professor Panitz described to me as a culture that was stubborn, resilient, and entrenched in this mentality, which when I came on the police department, almost 20 years ago, was an us versus them mentality. And that's how the police officers thought back then. And I think, the courage that it took these four crucial witnesses, not to mention the use of force experts who were also police officers that testified with this. The fear was that you are ostracized. You are you're put on the shelf. And today with this case, we saw that blue wall sort of collapse a little bit. Didn't go all the way down, but we have things that are in place right now. New Orleans actually was on the forefront of this. They have this program called EPIC, EPIC, and it's called Ethical Policing is Courageous. And it's where police officers themselves become bystanders. So, it was unequivocal, right? As Attorney Panitz said, it was unequivocal that we saw the heart-wrenching testimony of these four officers who relived for themselves the pain that it took. It was hard to watch. It was hard to watch that video over and over and over again. Zimmerman, you talked about him. I mean, what a great witness to lead off on, right? For me, that guy, I mean, when you look at him on the stand, he's this old guy. There's nobody there. He said, I'm number one in seniority in the department. That gives the jury credence, right? That gives him credence to the jury. Like when you saw them, right? You saw them in the aerial shot of the courtroom. You saw them when he talked, they kind of leaned in, right? And that's the psychology of the jury. Like they wanted to hear what this guy said. And what he said was, and I quote, he said, what I saw happen to George Floyd was uncalled for, right? And I took away quotes from each of these guys. Professor Panitz also talked about Jody Stringer, who was the immediate supervisor of Chauvin. And that testimony, the words excessive force was used, right? Huge. Inspector Blackwell said, I didn't know what provoked him to do this, right? We were never trained to do this, right? That's what the inspector said. That's what she said live, right? And then you have the culmination where Chief Arredondo said, this is in no way, shape, or form anything remotely close to anything we've ever trained about. It's not even on the map, right? And then what did he do after that? He fired everybody involved, right? Including Derek Chauvin. So I think that's a long way of saying the blue wall of silence, does it still exist? Absolutely. However, to the future of the job, and I see a lot of my students here, thank you for coming, a lot of my friends, a lot of my family, but to the people that aspire to be in law enforcement like me, I'm ready to kind of hang it up in a couple of months. But don't lessen your moral standing to be a police officer, because that's not what the police department is about anymore, right? We take an oath, we have an oath. That's what we're here. We don't want to do things that are uncalled for. We don't want to do things that are excessive. We don't want to do things that are in no way, shape, or form part of policy, right? We want to make the communities, we want to make good communities better communities, right? And that's what everybody in this room today is trying to do with these series of just conversations. All of the things that we talk about here is food for thought, and it should go into your arsenal when you become a police officer or any type of public service. Thank you very much.
Thank you. Thank you. So there were a lot of images that the court was concerned about the jury seeing. So I'll turn to you again, Ms. Watkins, and ask about jury sequestration. The jury was sequestered during deliberations, but the defense wanted the jury sequestered earlier for a variety of reasons. Please explain why a jury might be sequestered. What are the pros and cons of sequestering the jury? And well, let's stop there.
I think we can all guess why a jury should be sequestered or why the defense would want the jury sequestered. I mean, we've all gone through it, where you're at home and something happens and your family wants to know, well, so what do you think? Like, what happened? Or if you witnessed something or you saw something, it's like, come on, I won't tell anybody. Just give me a little bit of information. Just tell me what's happening. When there's someone sitting on a jury, we can't take that risk. So it makes sense that the jury would want, the defensive team would want the jury to be sequestered. It was my understanding. Now, I can admit that I didn't watch any of the trial. I just refused. I wanted to be surprised when it was over. I didn't have the wherewithal to just witness it over and over and over again. I just didn't. So I learned that there was a sequestration for a part of this trial where the jurors were driven home or driven to a secluded area. They weren't kept in a hotel, which is what normally happens, but they were controlled. Their movements were controlled from the courtroom to home and from home to the court building. So that I did not know during. So it's obviously very important, especially during high profile cases. Average trials don't last for weeks at a time. They're usually over in a few days. And it's not usually necessary to keep the jurors from having access to public information, public discourse, conversations, and the like. But where a case is high profile, such as this, it's necessary that the jurors have time and space to focus on the actual case and not focus on anything else. Don't feel the need to answer or defend or explain or anything else. So sequestering a jury in that sense, I think, is very helpful. The pros to sequestering a jury is that they have that time and focus to concentrate on what they're doing and to not be infiltrated by outside influences. I think that's the probably the greatest pro to sequestering a jury. I think the biggest negative is that people want to go home. They want to sleep in their own beds. They don't want to sleep in hotels for weeks and weeks and weeks. I think with the O.J. Simpson, it was over 260 days that jury was sequestered, I believe. That's a long time. So you run the risk of having people just do whatever they have to do because they want to go home. So let's hurry up and get a verdict. Even if it's the wrong verdict, let's do it so we can go home. So I think if you weigh the pros and cons of whether to sequester a jury, the level of public attention and concern and investment in the outcome probably dictates whether or not a jury should be sequestered. So I think they made the right decision here. Thank you.
Thank you. So it's time for our second poll. We want to know, do you think the jury verdict in the Chauvin murder trial is the correct verdict? So we've posted the poll. You have a minute to answer the question. Okay, so 85% of our participants think that the jury verdict was correct, that he is guilty. Thank you for participating. So we've heard some of the factors that the jury may have considered as they were reaching their verdict. Now it's time to discuss the verdict through a social justice lens. Social justice envisions a society that understands and values human rights. It recognizes the dignity of every human being, regardless of race, gender, social economic status, or other diversity dimensions. So again, I'll start with you, Professor Szobonya. Under the relevant sentencing guidelines in Minneapolis or Minnesota, how much prison time could Derek Chauvin be sentenced to? What factors will be considered to determine the length of his sentence?
Okay, well, each charge carries a different maximum. So the first charge was second-degree unintentional murder. That could be a maximum up to 40 years. The the third-degree murder charge could have a maximum of 25, and the second-degree manslaughter could have a maximum of 10 years. Now, under Minnesota, though, the presumptive sentence for somebody who doesn't have a prior record. So for that first second-degree unintentional murder, we're looking at 12 and a half years. 12 and a half years again for the third-degree murder charge. And for that second-degree manslaughter, we're looking at 4.5. Now, the prosecution is looking for an upward departure from the sentencing guidelines. Judge Cahill has the discretion to do it. What will he be looking at? I'm sure the prosecution are going to argue that this was a police officer, a person of authority who behaved in committing a murder in front of the public. There were many children that were around. There was a 9-year-old who testified and said that this was a bad person. George Floyd was an unarmed person in a vulnerable position. What will come into play also is that Derek Chauvin had made 8 prior arrests where those who were accused or arrested alleged that Chauvin had used excessive force on them. So now that information did not get into the trial. I believe that the prosecution was trying to get 2 of those prior arrests in, and then they decided against it, but that will certainly come in now, and there's 8 in total. So anything really about Derek Chauvin's character or habits will be up for information as opposed to a trial. That information did not come in. Defense counsel, on the other hand, will have to argue that Derek Chauvin had no priors, that this is the only thing that he has done. And he was on the police force for 19 years, and he did have some commendable actions. So whatever, whoever he can bring to the sentencing hearing to vouch for his character will come into play. A victim impact statement will occur, assumingly it will be George Floyd's brother. Another interesting point, though, about this trial, that George Floyd's brother did testify to the spark of life, which is kind of unique to Minnesota law and maybe some other states. We can talk about that later if we have time, but kind of on the same notion as the victim impact statement, showing what the victims are also losing as a result of losing George Floyd. Did I answer everything? I think so.
Thank you. Professor Panitz, so the prosecution focused on the behavior in this case of one rogue police officer. Do you think the prosecution missed an opportunity to address general police procedures?
I would say no. I think actually that the prosecution did go more broadly. I mean, if we start with the small and we get larger, we could see they did make some serious statements publicly. First of all, Jody Steiger, she testified there was excessive force. The medical support coordinator, Mackenzie, I think was her name, she talked about how the police have to render first aid and resuscitate someone who's not breathing. And there was no evidence that Derek Chauvin began anything, right? We could see he didn't even get close to doing CPR, right? So I think that was in the prosecution's case, that they asserted clear procedure and how it wasn't followed. I think they actually did some good here in a sense of removing neck restraint formally. Again, I'll defer to the lieutenant. I think Minnesota did not actually have on their books neck restraints as prohibited, and now they have banned it. Again, I don't practice that art, if you will, of policing, but that seems to be a positive change from the trial. The other thing I think that's very compelling here is that the other three officers, Cohen, Lane, and Tao, were charged with aiding and abetting second-degree murder. They're facing up to 40 years in prison with a trial in August. So I do hear your question, but I think the prosecution did a great job here, sending a message across the board. So, I hope that answers.
It does. Thank you. Dr. Hickman, so we know that we all have some amount of bias. What do you think law enforcement needs to do in particular to combat the effect of unconscious racial bias so that it does not affect how police enforce the law?
So let me make sure I'm okay. I'm not muted. So I'll say this: conscious bias, unconscious bias, all bias. It's really hard to unlearn something, right? Especially with our young people here. It's hard to unlearn something that and it's hard to teach also what bias is. And I always teach bias to my students, or especially other police officers, in the following way. If you were to close your eyes right now, right? So I want everybody in the room, close your eyes for a second. And students, right? You've all been there, right? You've all made the mistake, especially me. I've taken 8 a.m. classes, right? You're going to an 8 o'clock class. It's the first day of school, right? And you go on Rate My Professor, and this professor says, they say, don't be late to this guy's class, right? You'll fail automatically just by being late, right? So you go on, so you make sure you're on time, but you're running late on the first day, right? You park your car, right? You park in the student lot at RCC, you run across campus, you run to Academic 2, and as you're running down the hall, you see two students in the hallway, and they say, "Happy anniversary, I love you," to each other, right? Then just as that door is closing, right? Just as that door is closing, you manage to inch by and find a seat in the front row, right? And now the professor starts talking, right? Now that's your vision, all right? Now you visioned yourself, hopefully with your eyes closed, going through that scenario in your head, because this happened to all of us. Right, now, when you open your eyes, what is your mental image about what happened? All right, what's the race of that professor that you had in class? Is that professor Hispanic? Is that professor Black? Is that professor white? Right, that couple that said happy anniversary to each other, were they two men? Was it two women? Was it a same-sex couple? Right, your brain generates images of what is familiar to you, right? And your brain doesn't like images from what's not familiar to you, right? And so there's this part of your brain called the amygdala, right? Which generates something in your hypothalamus, which means it's where the endocrine system starts to trigger stress, right? And what I illustrated to you, just in that 10 seconds where your eyes were closed, was stress. Now, granted, the ideal, right, is that now we have the opportunity to work with a diverse faculty, right? By way of the schooling environment that Dr. Baston and Dr. Deere and all of our faculty have imparted upon us, right? We live in a society where you can marry the person that you love, right? But in your mind, when you mentioned that in your head, I'm sure the majority of the people here, that couple was a man and a woman. Right? But now that I revert you and I pivot you, and I say, well, that could be now a same-sex couple, right? That's implicit bias, Right? And so in the NYPD, we have fair and impartial training. That's something that we do. And I guess it's a long way of answering the question. You know, most police officers are well-intentioned individuals that want to serve the community. I see some former police officers here, some people that I've invited, all have taught me how to be a police officer. But what we don't know is that unconscious bias, you know, impacts people who are on a conscious level that may, like myself, reject racism, stereotypes, prejudices. I reject those things, but we all still have our unconscious bias. And one of the most critical points of this training that we have, called Fair and Impartial Training in the NYPD, is it gives us tools to sort of manage that bias, manage that behavior, right? It teaches you how the mind works, right? Because the mind is very difficult to change. You know, but we hold our status as police officers to a higher level, right? Just like we hold the attorneys in this room, imagine the judges, right? Everybody has these unconscious bias. Imagine your doctor, right? Your medical doctor has unconscious bias, right? And I'm sure that those biases, and there's another conversation going on like this in the medical world. So, you know, the bottom line for this entire thing, when it comes down to unconscious bias and this trial, we saw for 8 minutes and 46 seconds, right, a video of a white police officer and a Black victim, right? I think the motions in limine allowed us to call him a victim in this trial. We saw that those 9 minutes changed our history, but it may or may not have changed our unconscious bias. And you know, the 50,000 pieces of bait stamped information that was out there in this trial laid no foundation for our unconscious bias within. So as America cast their ballot, we cast our ballot here. You know, now we have a verdict, and now we need to talk about the unintended consequences and the really the overt consequences of what happened. And that's why these talks and these sessions are so valuable. Thank you.
Thank you. So Dr. Baston, based on what you just heard from Dr. Hickman, do you think the guilty verdict represents a, quote, watershed moment, unquote, in the pursuit of social justice?
I don't know if I can say that it represents a watershed moment. I can say that it is a part of this continuous journey toward justice in this country. I can tell you that the killing of Emmett Till was a point on the journey. I can tell you that the bombing of the little girls in that little church was a point along the journey. I can tell you Bloody Sunday and what they sustained on the Edmund Pettus Bridge was part of the journey. What Rodney King experienced in this country was part of the journey. And so we have to recognize that there are some days when there are moments that allow us to try to do better. You know, when we are coming from the Civil War and can see the 13th, 14th, and 15th Amendments passed, when we are overcoming some of the challenges that then ultimately allow us to have the Civil Rights Acts that have been passed. It is often in the midst of the journey in this country of all of us that change happens. So I do hope that the law will change relative to how we ensure that our law enforcement folks are supported and how we give them the guidance to do things that make sense and to keep our people safe. So there is a bill now in Congress named after George Floyd. There's been efforts to ban certain practices that are detrimental as part of the policing situation. There's efforts to try to ensure that we provide our training, better training and support and other integrated services in our communities where we see the rise in death of young people as a result of a number of consequences, police brutality and engagement being part of that continuum. And so if this is a watershed moment, I can't say that, but I can say that on this journey, if we continue to all lean in, we continue to participate in the jury process, because that participation allows those unchallenged narratives that our wonderful lieutenant just talked about, that we allow others and their experiences to be a part of the conversation. I believe all of the jurors had the real desire to do what was right based on their understanding of the law, their understanding of the evidence. And so I don't believe that that is the issue. What I do believe is the issue is that if folks are not at the table participating in the process, then that is what will continue to hold us back from moving forward. So this is part of our journey, but I believe our country can be stronger and better, and we all must lean in to address those things that are wrong and stand up for those things that are right.
Thank you, Dr. Baston. I did hear that pastor's cadence that you had going there. I just want you to know that. But I do believe that you teed it up perfectly for Ms. Watkins to follow up. So we know that President Biden encouraged Congress to pass police reform legislation known as the George Floyd Justice and Policing Act. What does the Policing Act attempt to do? What are the stated objections to the bill? Do you think it goes far enough is a question. And do you think it will pass in the Senate? As one person notes in the chat, it needs 60 votes to do so.
Yes, well, the purpose of the George Floyd Justice and Policing Act, which was introduced by Kamala Harris and Cory Booker in 2020, soon after, I believe it was June, soon after George's death. The purpose was to hold law enforcement accountable for misconduct in court, improve transparency through data collection, and reform police training and policies. I think the challenge is that this is something that needs to happen on a local level, on a state level, as well as a federal level. So we can't just depend on the federal government to legislate police conduct in our communities. We have to be a part of that. So there are national registries that are part of the George Floyd Policing Act. And that registry, because a lot of times police officers will leave one jurisdiction and go work at another jurisdiction, but no one knows the record that they left behind. A part of one of the benefits of this registry is that there are no secrets anymore. The next jurisdiction will see what the officer did in the last jurisdiction and then have a fully informed decision as to whether they want to hire that officer in their police department. That's similar to in New York, I believe it was last year, the governor and the state assembly and Senate repealed 50A in New York State, which allowed for communities and the public to have access to police records. So you can foil a police record to find out what the police did, what their records are in past jurisdictions where they've worked or the current jurisdiction where they are. There's a lot of pushback to that, a lot of court action for that, but as of right now, I believe it's still, you can still foil Freedom of Information law, police records. The act is 54 pages and it covers holding the police accountable in the court, Law Enforcement Trust and Integrity Act, policing transparency, pride, improving police training and policies, prohibiting racial profiling, and the Federal Police Camera and Accountability Act. That's important. Everyone knows the, did they have their camera on at the time that they made the arrest, at the time that they made the stop. That's paramount because as we saw with Floyd case, the camera, the young girl, as Professor Panitz described, the 17-year-old girl who recorded it, probably is the most responsible for the conviction. So I think, I will say that last year, September 11th through April of this year, I had the opportunity and privilege of sitting on the Rockland County Sheriff Police Reform Panel with Professor Barrett, who works at RCC. We were both co-chairs with Grant Valentine. And many of the provisions contained in the George Floyd bill, were also a part of the recommendations that we sent to the governor for policing within our county. And all police departments in New York State were responsible for submitting a report of reform to the governor by April 1st. So again, I will end with saying that for all of the provisions and beautiful outcomes that will be a part of this once it's implemented, on the local level, we still need to work. January of last year, a friend of mine, Tina Davis, was killed after an interaction with the police in Spring Valley. And George Floyd obviously happened after her death. So there's still work that needs to be done on a local level. So I say her name every opportunity that I get. Tina Davis, thank you.
Important. It's time for our third and final poll. We want to know, as a result of the verdict, which of the following you plan to do. Please show the poll. Thank you. I'll give you about a minute, maybe a little longer because there are a number of options. So 71% of the respondents indicate that they want to educate themselves about social issues, which is incredibly important. Followed closely, though, by 64% of the participants indicating that they want to support organizations that advance social justice. I think it's important that if you feel like the change needs to happen, you need to help change happen. So you can do it in any number of ways. Those are just a couple of the ones that we thought of, but I want you to kind of keep that in mind. Because we know that when people stand up and speak out, our system can work. It can get better. It can treat everyone fairly. So thank you for sharing your thoughts. So it's time for Q&A from the audience. You can put your question in the chat, or you can raise your hand if you have a question for the panelists, and I will call on you. I see one is already in here, so I'll start with that one, and anyone can answer. Does the George Floyd Justice Bill include an element similar to Carroll's Law, requiring officers to intervene in cases when other officers use excessive force? And someone else is saying yes. I'm just not sure if yes is to that question.
And in my review of, I actually printed the entire thing. I didn't see anything specific to that. I mean, it very well may be in there, but I didn't see anything related to that.
Anyone else? You can put a question in the chat, or you can raise your hand, and strategic marketing will help me find you. If you don't raise your hand electronically, it doesn't immediately pop up on my screen. So if you're raising your hand, I cannot see the gallery view at this point. And so Sharon Mellis, please come off mute and ask your question. Sharon, you've got your
Sorry,
hand
can you
raised.
hear me now?
I can, thank you.
Okay. I was wondering about Judge Cahill's statement that the comments of Congresswoman Waters may be grounds for an appeal. You know, the country in general, I think, is so invested in, you know, what was the outcome of this trial. I'm curious as to what we think an appeal might look like, what the legal basis would be, how likely we think, what we likely would think would happen if an appeal happens.
Thank you for the question.
I can add a little something to that. What my understanding with Judge Cahill is that he was not happy with the Congresswoman's comments. However, I don't believe that he thought that it would be grounds for a successful appeal, of course, you know, to win the appeal. Something that I thought of that might be grounds would be that spark of life testimony that was given at trial by George Floyd's brother. That testimony, we don't have it in New York, and we don't really have it in many states, because it's testimony to just breathe life into George Floyd, that he was an actual person. And this whole case is surrounding his death, so they want to spark life into this person to make him human and sympathize. That testimony, however, does not go to any one of the charges or any of the elements that need to be proven. So I would be interested in that outcome to see, you know, there's a reason why most of the states don't have that particular testimony provided at trial.
Thank you. Any other questions from the audience? So here's one in the chat. Does his guilty verdict lead to any significant change, or is this just a temporary relief for now?
I think it depends on all of us. Everyone on this panel tonight. It depends on you. It depends on me. It depends on what we're willing to do in our communities, because the reality is George Floyd didn't die here, even though he has visited here. He has family here in Rockland. He didn't die here. So it's many times our communities are separated and detached from the reality of horror that happened somewhere else. We need to look into our policing in our local communities and make and advocate and move for whatever changes we think are necessary. No, there may not be a police shooting, but there may be other issues that exist within our local communities that we need to address. We should not wait for George Floyd to happen in Rockland County before we become concerned and involved.
I would also add that I am concerned that the current desire to engage in and lean into social justice may lose its intensity as we go back into our world of work, sort of hamster wheel mentality. One of the things that enabled the kind of consciousness of the country to be raised was the fact that we were in COVID and we were home and we were not able to venture out in large numbers, and we were fixated on this story and its outrage and how it affected us and our emotions, and our ability to then all across the country, regardless of race and ethnicity and background and age and sort of resource set, came together and began to collectively grieve about injustice. What concerns me is that element of not having a focused time to think deeply about how together we as a country continue to move toward dismantling structural racism, as we together continue to address the issues of inequity in our country. I'm hopeful that, you know, this is not simply this was a punctuation mark in this situation, but that same level of national collective action then recedes because we try to find some sense of normalcy going back into the sort of on the hamster wheel. And that is a major concern. And I'm hopeful that all of us will continue not to just limit the conversation to the policing aspect, which is extraordinarily important. But there are so many systematic things in our country that need our attention and our together leaning in to address them. And that is what I'm most concerned about.
Thank you. Any other questions from the audience? I'll give you one more moment. Okay, thank you. So we'll wrap up. I want to wrap up with a few facts and final thoughts. I've tried hard to keep my own opinion out as I've allowed the panelists to share their thoughts, but I couldn't resist. So according to the NAACP Criminal Justice Fact Sheet for 2020, a Black person is 5 times more likely to be stopped without just cause than a white person. 65% of Black adults have felt targeted because of their race. Similarly, Approximately 35% of Latinx and Asian adults have felt targeted because of their race. Despite the fact that more white people have been killed by police, Black and Hispanic people are disproportionately impacted. While white people make up a little more than 60% of the population, they make up about 41% of fatal police shootings. Black people make up 13.4% of the population, but make up 22% of the fatal police shootings. On average, Black Americans are exposed to 4 police killings of other unarmed Black Americans in the same state each year. Think about that last one, the mental health burden alone. A single verdict will not undo the legacy of racism and oppression in our country. However, it can be a catalyst, as Dr. Baston mentioned earlier, for the types of reform we need. All members of our communities must be treated fairly and with dignity and with respect. Our judicial system must provide justice for all of us, and our communities must be safe. That means we must be relentless in our efforts to combat systemic injustice. I hope we've given you some things to think about when you think about the Chauvin murder trial and what, if any, lessons may have been learned. Thank you to the audience for joining us tonight. Thank you for the panelists for sharing their thoughts with us. A big shout out goes to Strategic Marketing for facilitating this Zoom experience. I do, however, want to remind you that this is Unity in Community Week, and we have a number of events that are going on. And I want to highlight 2 of those events. So I ask you to consider joining us on Wednesday at 1 o'clock for a book talk with author Mark A. Torres, who's going to talk about a painful time in our history, very close in proximity to where we live here in Rockland County. And also on Thursday at 2 o'clock, we're going to have another panel discussion made up of RCC faculty members to talk about what's next after the 2020 election. Coincidentally, on that day, we'll be 100 days into the Biden-Harris administration. And so it'll be very interesting to hear what we have to share. I hope you will consider joining us. Thank you very much for being with us this evening, and I wish you all a good night.